Today we're joined by the CCMA. It's an episode that many of my friends personally have been waiting for. And I am joined by Commissioner Molefe, an incredibly wise man. So if you're an entrepreneur, if you know an entrepreneur, if you are working for an entrepreneur, this is one show that you need to hit that like, you need to share with your friends, because a lot of misconceptions about the CCMA are out there, and Commissioner is here to share his wisdom, and Commissioner is here to educate us about wherever you are on the side of the spectrum, what your options are. So, welcome, Ntate Commissioner.
Thank you, and good morning to your viewers and your listeners.
Yes.
It's an honor, and it's quite a privilege to be here. And it's an opportunity that we always, looking forward to.
Yeah. That's one thing we appreciate with you. As big as your brand is, we would assume that it's hard to reach out to you. That's the assumption that was there with,
of course,
many entrepreneurs.
Yeah, we talk about a myth. As the CCMA, we have a special department that calls dispute prevention and workplace outreach, where we interact with our users. So there's capacity building so that our users are able to deal with matters and understand what the CCMA is all about. That's why we appreciate platforms like this. And critical, it's also to remind your viewers and your listeners that the CCMA services are for free, and we don't only deal with dispute prevention. In other words, we don't wait for things to break down.
Go bad before you get involved.
That's why we say we have a discretionary function called dispute prevention. It used to be called dispute management, wherein all our users, I'm referring to labor, I'm referring to business, I'm referring to government, NGOs, NPA, everybody who needs information can just contact the CCMA, and then
I think we'll get quite a lot more of that, because I want to give our listeners and our viewers a brief segment of what we're going to cover today.
Sure.
But I'm not going to cover this alone. I am with a very good friend, an HR pro, a recruitment specialist, this Noctula Molefe. I guess you want to say hello as well.
Yeah.
Well, hello to the viewers and the listeners. It's a pleasure to be here, and we look forward to learning. And I think these sessions are really about that.
This is an area you're passionate about.
Absolutely.
Because it's right in your space.
Yes.
All right. So we divided the segment into 4 sections.
All right.
We are going to look at dismissals and unfair practices. That's where we'll start, because that's what the CCMA, for the most part, is popular for. We are going to look at workplace harassment and discrimination. And then we'll look at rights and responsibilities of owners, rights and responsibilities of employees. And in the last segment, which is what many of you will be waiting for, we're going to look at the money. Who is entitled to what, and how is it dispersed, and why are people winning or losing cases? We'll look at the money. I was asking a few people earlier on what they understand the CCMA stands for.
Okay. The CCMA is a Commission for Conciliation, Mediation, and Arbitration. As the CCMA, we are a forum of equity. Hence, earlier I mentioned that we don't represent anyone. We are there to make sure that the citizen of this country taste the fruit of democracy. They enjoy the constitutional rights. In other words, we are here to make sure that there's this principle of fairness, and fairness is a two-way process, of course. Fairness for employers as well as employees, especially the most vulnerable, the less sophisticated, whilst at the back of our mind, we remember the history where we come from. That is why when you look at Section 1 of the LRA, it speaks about social justice. And
when you say the history that you're coming from, which
the pre-1994 history where there were injustices and people did not have right, an employer can just, do what he or she pleases with you employer will kick you out anytime. And now we are in a jurisdiction where we call it a just jurisdiction, because we have to follow the prescripts of the law. We have to follow the constitution and legislation. We are not a at-will jurisdiction where the employer can do as they please. They need to observe certain legislations and follow the dictates of the law, so that in the end, as a commissioner, if the matter is referred to me, my role is not to run the business or the operation. My role is not to tell the employer who to dismiss when and how. My role is to look at whether the decision arrived at is fair, because the law talks about fair. I'm
Fair
not
on both
looking at
sides.
the lawfulness, the legality, the validity. LRA says, look as to whether this was arrived at fair. The flip side of that means it can be unfair. If I find that there's been unfairness, then the remedy is reinstatement, reemployment, or compensation. And we don't prejudge these cases, remember? Yeah, we don't prejudge the cases. The OD alteram patem apply. In other words, everybody has the right to be heard, and you are presumed to be innocent until you're found otherwise.
So what constitutes unfair dismissal?
Okay.
And the follow-up question to that, based on what you said,
Okay.
you said everyone deserves to be heard. What happens then if I am an employer and I decide not to come to the inquiry?
Yeah, okay. We'll come to that point.
Those
But
two.
the will of justice 10, whether you are there or not, you need to be aware of that.
Absolutely.
The process will continue. Your absence does not stall the process. We don't get jurisdiction from you. We get it from the law. So the law does allow us to proceed under certain circumstances.
Okay.
Yeah.
I think in my experience as well, would be the other way around, where the employee does not talk. But
Yeah.
most of the time, employers, they know what's at stake, and they need to show up. They need to be there to present their case, why they arrived at the decision. So I think the people that we should obviously make emphasis on is the employees, at the importance of appearing.
Yeah. That's why we say in labor laws, the right to remain silent does not arise. Because it's a hearing, you must come, you must be heard. If you
Absolutely.
choose not to come as an employee,
Yes.
the process still will unfold. And as an employee at the level of the CCMA, if you don't arrive, because we want to ensure it, there's justice, there's access, as a commissioner dealing with the matter, I'll make an effort to find out from the file whether you've been served correctly, the details are there. And I also go that extra mile of making a call to find out where you are, because you'll never know. The same would apply to the employer. Then
Yes.
if I'm satisfied that you have been served properly, everything is in order, I will proceed to dismiss the case if the employee is not there.
Yes.
But there is a recourse in that as an employee, if the case is dismissed, it's not the end of the world. You have to apply for what we call a rescission. Rescission to the CCMA, so that the CCMA can look at that the reasons that you are giving, and if they accept the reason that they are valid and their prospect of success, then you can say, okay, we will reschedule the matter, or you can apply again for the process.
Okay.
Yeah.
If it's an employer, we'll do the same, check the whereabouts, check the details. If the employer did not pitch, like you were saying earlier,
Yes.
if the commissioner is satisfied that this employer, his absence is willful, then the employer can proceed in default.
Yeah.
But the same recourse does apply, wherein the employer can say, no, I'm applying for rescission. Maybe I was not aware, I was sick, I was caught up, or there was a strike, I couldn't arrive with it. All those things will be looked into. And then
Yeah.
at times, the commissioner can decide on his own to rescind the matter.
Yes.
But everything will depend on the facts. So the important thing is, if your case is dismissed or the process went on in your absence, do not panic. Ask what is the recourse to that. You will represent small business, and then the CCMA will by all means say, hey, we are not in heaven. We are here, can be reached by phone, by email.
Absolutely. I love that. Mr. Molefe, there is something that I think would be quite beneficial for our listeners before we go into the unfair dismissals. In my previous lifetime, where I was also an employee, in HR, where the process is not clear. The process to follow with the CCMA. Say there's a dispute and we've arrived at the decision to say either a dismissal based on whatever circumstances. Now, who files? How do they go about it? Then what can they expect in terms of the process within the CCMA?
Our process is very simple and straightforward, provided you've got the right information.
Yes.
Now, if it's an employee who has been terminated,
yes,
the employee will come and make that allegation. It's an allegation.
Yes.
So this needs to be tested to say, I have been dismissed unfairly because of a misconduct. Remember, there are 3 grounds for dismissal.
Yes.
Can be misconduct/behavior, can be incapacity, ill health, injury,
yes,
performance or incompatibility, and the last one can be operational requirement, which we call retrenchment. Now,
yes,
the employee will tell us what is the issue.
Yes.
And then our capable staff, who are men in the front desk, will be able to assist the employee, complete the 7-11, and then refer the matter, serve the employer, because an employer must be served.
The form is 7-11.
7-11.
7-11, okay.
The employer must be served because the employer needs to be aware that there's something coming.
Okay.
And they need to prepare themselves. We can't ambush the employer. And again, the CCMA can say, look, you are late. Your application is late.
Okay.
You could have applied within, let's take it
30 days
from the date of dismissal.
Okay.
And then what we do now, your recourse is apply for condonation.
Okay.
So that the CCMA can decide whether they condone your behavior or they don't. And then we'll take it from there. Now, because of advancement and changes in technology, there's also an online application that can be made from the comfort of your home.
Okay.
You can do an online application. We live in a new digital world, and the CCMA, by all means, is following those trends.
So we're saying there is a time frame at which to report this within the CCMA.
Absolutely.
If you are the applicant. So that time frame is 30 days from the time of dismissal. So if I was dismissed on the 2nd of February, I've got 30 days. That's working days.
Yeah.
I just want it to be...
No, calendar days.
Calendar days.
Don't deal with working days.
Okay.
There are people who work 5 days, 6
Yes.
days, 7 days.
Okay.
And now, to accommodate everybody, it's calendar days.
Calendar.
Every day counts. Including weekends, including holidays. So
Perfect.
30 days. If it's a discrimination-related issue, then, or unfair labor practice, you have to refer within 90 days. Not 3 months, 90 days.
Okay.
And then if it's a discrimination issue, within 6 months. So those are the timelines that we need to be aware. But not always most if you are late. That's how we talk about condoning your lateness based on the number of days, the reason, the prospects of success, the prejudice to the other party, if any, or any other reason that you can submit to in that application. And it will be weighed and a decision will be made. Now, what happens if you have appealed?
Okay.
Remember, you get dismissed on the 1st.
Yes.
You'll be put in an appeal within 5 days. An employer decides to sit to beyond the prescribed 30 days time limit. What do you do now? Is it all lost? No. The employer decides on the 30th or 60th day to give you the outcome of the appeal. That's where you count your 30 days from the date of the outcome of the appeal.
All right. There's something you mentioned. You said you don't want to ambush the employer.
Of course.
Once there's a report, what constitutes evidence on both parties?
Okay. Evidence.
If I'm defending myself,
is what you bring to the table to prove your case at arbitration. It can be in a form of witnesses. It can be in the form of documents. It can be video footage. It can be recordings, etc., etc. Those are things that we use to prove that indeed there was a commission of this or there was no such a commission. That's very important. We have different forms of evidence, circumstantial evidence, you get your oral evidence, polygraph, all those things.
Polygraphs.
Yep.
Yeah. But remember, polygraph is not a standalone evidence. It needs to be surrounded and supported by other forms of evidence. It can prove.
Have you had situations with small business owners where they struggle to provide the evidence that you're looking for? They don't have the video footage, and when it comes to witnesses, the other employees are afraid to stand for either side, and so the owner is stuck, and they might not even have contracts.
Yeah, you're speaking about the contract. You're talking about a written contract.
A written
Remember,
contract,
a contract
yes.
is an agreement between two or more parties.
Yeah.
It does not necessarily need to be in writing, because even a verbal contract has got the legal force and effects because there's no dispute that I'm working. But we prefer a written contract because it's easy to prove. For small employers, remember, CCMA is about access to justice. That's why we say we are a forum of equity. Once you arrive at the CCMA, you have no clue what the CCMA is all about. You are panicking, you are afraid. As a commissioner, I'm duty bound to say, look, madam employer, there's no need to panic. This is how the process is going to run. And the first leg is about conciliation, which conciliation is an informal, user-friendly process. The objective is to try and see if the parties themselves can arrive at an agreement or settlement. And if they arrive at the settlement, can be reinstatement, re-employment, or compensation. So that's what the powers that we have as commissioners. So now if we decide to reinstate, meaning you go back as if you have never been dismissed before. Re-employ, you say, no, I take you as a new person because of other reasons that you need to explain. Compensation is not an acceptance of guilt. To say, in the interest of saving time, I don't necessarily accept that I'm wrong. It's not, the conciliation is not about wrong, right, win, lose. It's about finding the middle ground. And the destiny of this process, it's in the parties' hands. We make you relax, understand. If there's any question, you can ask, and then we'll take it from there.
Okay.
As the system. A very, very, very user-friendly. It's non-complicated. That's why even legal representation is not automatic, especially for misconduct and incapacity. Consultants, I'm sorry, my sister, consultant cannot appear. Anybody wanting to apply for legal representation, to represent must come and apply before or during a process as a legal, and let the commissioner determine whether is it worth it or not. There's matters in employment are very easy, but really complicated.
I like that we've just spoken about that particular process of conciliation.
Yeah.
Now, we're at this stage, we are either looking at agreeing, and if we don't reach that agreement, if I'm not happy as an employee who's lodged the grievance, I'm not happy with the outcome, whether it is compensation, whether it is, because companies can say 3 months, and I think, no, I actually should be getting 12 months, I should be getting 6 months. What then is the next stage? Is it arbitration? And what happens then? What can one expect from arbitration? Because you've just mentioned that conciliation is quite, you said it's off the record. So when we now take it to the arbitration leg or stage, what can one expect from there?
Okay, let me correct something.
Yes.
We are not the grievance resolutionists.
Yes.
As the CCMA.
Yes.
Grievances must happen.
Yes.
When it's escalated to the CCMA, it's now a dispute.
Yes.
As you are called a dispute.
A dispute,
resolution,
yes.
And the big one in the world.
My mistake, yes.
Yeah, no, no problem. I'm just explaining for the benefit of the viewers. Now, if we don't resolve a matter at conciliation, because parties do not agree, it's your right not to say, no, I disagree. And much as also is the right of the employer to say, no, I'm not budged, but we want people to be open-minded. Now we'll issue a certificate And then the next process would be arbitration, like you are saying.
Yes.
Now, at arbitration, the commissioner will explain the process. You'll take an oath or the affirmation, and then you'll explain that who has the honors. If the dismissal is not in dispute, the employer is the one who's going to start. If the dismissal is disputed, the duties on the employee to prove that there was a dismissal by leading evidence,
Yes.
oral evidence,
Mhm.
Circumstantial evidence, video footage, documentary evidence, or whatever form of evidence that they will submit.
Uh-huh.
And then after leading evidence through your witnesses or on other various means, then the other party will have a right to cross-examine or ask questions, just in an effort to collapse the case of the other party. And then at the end of that process, the commissioner now is the one who's going to decide who's a winner, who's a loser. And then within 14 days, the commission you must have received the outcome, unless, of course, there are reasons why there is a delay, there's a postponement, because at times there are reasons why you don't get an award within 14 days. There may be the commissioner was sick, or the evidence was voluminous, it was huge, the commissioner is not able to finish on time. All those things will be looked at. But the CCMA is very strict on, allowing people to exceed the 14 days. Hence, internal policy must submit within 10 days, failing which there will be consequences to that. Because we want people to matters are resolved as quickly as possible. We must move on with our life. But what I must highlight is that anybody who comes to the CCMA believe that they have a strong case.
Of course.
Until they are proven right or wrong.
Yes.
Hence we say, let's try conciliation, put conciliation first, let's talk. And by then the temperature would have been cool, ready now to face one another and have an understanding and settle the matter. Yeah.
So business owners can approach you to report an employee. When that has happened, what are examples of cases that business owners can bring to the CCMA?
Look, for example, if there are retrenchment issues, you employ more than 50, you can approach the CCMA. Or you can, even before you make a decision, approach the CCMA and find out exactly how you can go about the process. There's no harm in doing that. And you don't have even to come. Can a phone call, send an email, and an explanation will be given without giving the outcome information, without giving the outcome that you'll win or you'll lose the case. Just give you information and what is the procedure. Remember, there is the procedural fairness and substantive fairness. There's the two legs that we normally test. Procedure, did you make an investigation? Did you notify the employee in writing? What are the charges? And what is the allegation? Simple allegation. Did you explain the date, the time, and the venue? Did you explain their rights to them to be represented by a union? If there's a recognized union, not an unrecognized union. By a union to be represented by a colleague, the right to an interpreter. It doesn't matter whether Nokuthula is good in English. All the 12 languages enjoy equal constitutional rights. So the right to an interpreter, the right to access information or evidence, and the right to be heard, which is central to our legal laws. And the outcome must be communicated within reasonable time. And even the timelines that you're talking about, you need to indicate to say, please, don't waste time, refer the matter to the CCMA. And if you say to an employee, I know people at the CCMA, no, you won't succeed.
No.
You are now tarnishing the reputation of the CCMA because it's a lie. You can't do that. If you do that, you must know that you are now pulling the name of the CCMA in the mud. Just say to the employee, you have a right to go there. Because you will be called. Remember, it's an allegation. You will be called to come and explain it yourself. Now, at times, especially with small employees, say, no, I've done what I have to do. It's my business. Nobody says it's not your business.
Yes.
But come and be heard.
Yes.
It's as simple as that. Come put your case to this is what I have done. If what you have done passed the test of procedural fairness, by all means, then the second is the reason. What is the reason for the dismissal? Is there a rule or standard? Is it valid? Is it reasonable? Is it consistently applied? Is the outcome or is the dismissal an appropriate sanction? By the way, we are not always dismissing. You can come with a sanction called short of dismissal. Meaning you go to a hearing. After a hearing, chairperson says final written warning or written warning or demotion or this or that. You have a recourse in that you can still refer to say, I'm not happy with this. So those are the two.
So that those two actually answer how you arrive at the decision of this was an unfair dismissal.
Absolutely.
When I think about the second one, constructive dismissal.
All right.
Yeah.
The way you were describing evidence, it's like if I wanted to, or if an entrepreneur wanted to fire someone, they can take time to prepare the evidence. If you did not have the intention to fire the person in advance.
I don't want to put fire first. I want to put manage.
All right.
And that's exactly where I wanted to go.
Discipline.
So
yes. That's the point, that because my takeaway from what you've just said to us now, I think you've also hinted to say there is evidence that can be brought forward by either parties. As you're saying, it's obviously all of, and my advice, which is something that I've always said during my career and even now, is to say, as you said, evidence can be, contract can be verbal or can be written. I prefer written.
Sure.
Because it's in black and white and people get to sign to acknowledge that written content to say, I agree to these terms and conditions. Now, I've seen a lot of my colleagues not understanding the importance of these contracts, not understanding the importance of these policies that Mr. Molefe just has mentioned. And we tend to negate and just forget about that and say, no, but I told that person. But you see, as people, especially in the employment, there's a lot of things that are happening that change, that sometimes you can end up victimizing certain individuals because of the fact that there's so many things that are happening, so many things that are changing. But with the written document, you have a standard practice across the organization or the business that you can always refer to should a dispute arise. And if you don't have that, then it becomes very difficult for both parties to appear before the CCMA to justify their stand. And that is why I always say, even as a small business, try with everything that you have to make sure that there's written document, contract of employment that stipulates the times and the conditions of employment. Make sure that the job descriptions are also outlined there so people understand what their roles are, because there can obviously also be disputes around that. Make sure as well in terms of the policies, because most of the time we find that most of the disputes come in with the policies. And that's why you'll find employees going to, after dismissal, they go to the CCMA, however, have not really considered what the policy document is saying. So from the employer's side, make sure that the policy document is very clear. And for those that don't understand the language, make sure that there's somebody who can explain those terms and conditions in terms of the policy. And from the employee side, it's critical that when you come into that employment, you ask for that. That's your saving grace. Even if you go to CCMA, that is your grounds of justification. If you know that this is what the process is supposed to be, this is what the company set out as rules, and I have not crossed any of these rules. If you don't have that, then it's just a hearsay.
So let me ask, as an employee.
Yes.
And I'm looking at you starting to let me sign these written warnings and take video footage. What do you think that communicates to me? Because I can then start seeing that this one is planning something.
You're saying as an employee?
The act of compiling the evidence.
Yes.
If it takes you 3 months, 4 months, while you start compiling the evidence, as an employee, don't I see that this is what you're doing and you probably want to let me go in a couple of months?
But that you would have obviously done something. I don't think, look, like I said, if that documentation, like the policy, let's say, for example, somebody absconded, because that's what I used to deal with a lot. especially in the in the blue collar space. When it comes to December, a lot of people would not show up, in January because they just want to extend their leaves. So that your leave days that you took were 5 days. Then you ended up taking 8. Now, as I'm putting this document together, obviously the conversations are happening because I would have tried to call you. Where are you? Why are you not at work? So already from there, that I'm putting stuff together and I'm going to maybe set a disciplinary hearing for you. So I don't think there's anything that happens without your knowledge, especially when you have what is this word? When you have done misconduct, when there is something that you've done, you will know. So it's not like they are hiding this information, they're compiling this information. And I'm not saying that it doesn't happen. There are constructive dismissals, as you're saying, that sometimes those kind of things are done underhandedly where employees don't know. But
because
I guess we can let
that's what I'm thinking.
Yeah.
If it's a constructive dismissal,
Yes.
someone will plan it and start preparing the evidence, and the employees can pick up on it.
And that they do.
Something is going on.
Let me explain that constructive, because the
Please.
dictionary meaning of constructive is just like you are planning. But
Yes.
in terms of section 186 of the LRA, meaning of dismissal, constructive dismissal arises when the employee alleges that the employer has made the employment relations intolerable. Now, what is the trigger for constructive dismissal? The employee resigns.
Yes.
2, the employer is to blame
Yes.
for the situation that the employee finds themselves in, and the working environment is intolerable.
Yes.
Now, that is the onus. The onus rests with the employee
To prove.
proves the intolerability of the situation, and the employee also must demonstrate or prove what is it that they try to do. If they follow a grievance process, if it's possible, and then is the situation that bad that any reasonable person amongst ourselves can look at it and say, here, it was so intolerable that this employee, couldn't just withstand this situation. That is constructive dismissal. You resign first, and then the employer must to blame for consider intolerability in that space. So it's not like you just up and go and you just go and do these things. We've seen people resign. You see their cameras here, and then there's a farewell function, and they make a moving speech thanking the employer and telling the employer they find greener pastures.
Yes.
And later they rock up and say it was intolerable. And that evidence that you're talking may come to the fore. The letter that you wrote, a rosy letter.
Yes.
Very poetic. You wrote praising the employer and regretting that you are leaving, but unfortunately you have other things to do. Those, the employer can come and demonstrate that, no, this was a happy chappy. It's just when the person arrived at the Department of Labor, they were told, no, you resign. You can't access your UIN.
Yes.
When you resign, you don't. Just by constructive. So the onus is on you.
Yes.
As an employee.
What if it's hard
is
to prove?
raised very high for you to be able
Absolutely.
to pass the test?
Let's move to the next segment, workplace harassment, because that's the root of this. What if it's hard to prove? The harassment is hard to prove. It is, someone can come and not say anything, but just have an angry face every day when they're in front of you, and it just makes you scared. I don't know how to best describe it, but someone who doesn't verbally say it, or sometimes they can verbally abuse you, but just being there, they can give you a look that gives you a presence that says you are not wanted here. That's hard to prove to the CCMA. How will I come and say, boss just comes and keeps quiet?
Yeah.
Yeah, look, with harassment, it's an EEA, employment equity, where you are alleging that you have been harassed, you've been bullied, you've been intimidated, or you've been sexually harassed. So when you bring those matters to the CCMA and say, look, I have been discriminated against because I was treated differently as compared to my colleagues. This is the conduct, the silent conduct that I've been given, which obstruct my ability to and I don't feel comfortable, I don't feel okay. It's an allegation. it will be put to the test. And remember, discrimination is deemed to be unfair until it's proven to be fair. In other words, the law does provide that you can't be discriminated.
So you start off by saying I'm guilty.
It's deemed to be unfair until it is
proven to be fair.
Okay.
In other words, the employer is not barred from discriminating against employees unless it is within the confines of the law. Remember, that's why discrimination is always qualified with unfair and fair. For example, if we talk about affirmative action, it's permissible. Inherent requirement of a job is permissible. Or any other justifiable reason. You must be able to, for example, simply put, to explain why are you paying these two people differently. It's a discrimination. Then you must explain why. What are the reasons? What is it that you consider for you to have that pay differential? At face value, it looks unfair. But
Commissioner, that one.
Yeah, you may find that, there are things that you are looking at, before you make that decision. But if it is found that your section 11 is very clear of the EEA, it says, if discrimination is alleged on the listed ground, remember the listed ground in section 6.1 of the EEA, if it's alleged on the listed ground, the onus is on the employer to prove the fairness of the dismissal. If it is alleged on arbitrary ground, those are grounds simply put that do not appear on the listed ground. Because you are short, like you are arguing about the short. Fortunately, the commissioner will be able to guide.
Okay.
And then you also have your sexual harassment.
Mr. Malefit, that's a very difficult one for employees to prove, though.
Which one?
The one on unfair pay, where, and I'm going to go there. I'm going to go to saying a black person versus a white person will not be getting paid the same salary. So that's a very difficult one because remember also the policies, most of them, they state that you're not supposed to share such information. That's for start. So before you even get to the CCMA, the company would have dealt with you first to say, but how did you know what so-and-so is paying? Because that's not information that you're supposed to have. And for example, if you're HR, which is sometimes where we would find ourselves and we would see these discrepancies, there is nothing that I can say or do about it, even though I see them broad daylight and I can see something is not happening here. Like, for example, when we're recruiting, this is the set budget that we have been given by the business unit. They want to hire somebody at probably 8K. Now, there's obviously the terms and conditions in terms of the criteria of the people that need to be considered for this position. When we go to the negotiation tables, those discussions are the most difficult conversations to have to say, but if you can give Peter 800, surely you can give Vusi the same amount of money. Those conversations it's not easy to have those conversations with line managers that are recruiting. I've seen this from my experience and I know it happens. And I think that's one of the things that used to really rattle me up because there was nothing, I felt disempowered to be able to speak about that. But because of the position that I've taken, I have to allow this injustice to happen where Vusi with a degree and the experience gets to be paid less than what Peter is going to take home with no qualification.
Okay.
Actually, to add to it, just to pick up on one part of a question, if the company has a policy that says these are confidential and an employee is coming to report to say, I am unfairly paid, and the company is coming and saying, how did the employee know?
Okay. Now let me respond like this. A policy is not prescriptive. It's not a piece of legislation.
Okay.
It's a guideline.
Okay.
When you have that policy, it's fine. It's acceptable.
Okay.
But remember, as a CCMA, we derive our jurisdiction from the law. The Employment Equity Act permits us to deal with those issues. Now, if you get paid as Ntando, it's confidential. But once you make that information available to your union, the union can act in your interest. Or you yourself, if the other person compares, their payslip with yours, which is not bad, it's theirs, and they compared with you. And the BCA Section 78 or Section 79 is very clear that you cannot, interfere with that. For policy purposes and internet, it makes sense. But now the law, it's above your policy. You need to understand that.
But the law is above your policy.
If you come to the CCMA and want to argue issue of confidentiality, just remember that's outdated. Because the first question that I'll put to you as a commissioner, are you saying we do not have jurisdiction to deal with pay inequality? And you must tell you which law give you that right. Because in terms of the EEA, I can deal with such matters. I can entertain such matters. And now the onus will be on you as an employer to produce evidence or put it to the fore, say there's a payslip. And again, I must go back to the issue of fair discrimination. You may be able to justify, you raise a race issue there to say, because I'm black and I'm white, we're not being paid the same because of the following reasons. And of course, historically, we know those injustices. Hence, you will find your equity plans to try and address those issues.
Yes.
And then they will be looked into. But it comes as an allegation. An employer can be able to say, look, these are our market forces that has made me to pay this person more than you. He's got the experience and the skill is in demand and there was competition. And for me to be able to have hired this person, the only way I could have, and it's a critical skill, is to pay them, a better because I had
a competitive salary.
And we'll also look at your equity to say, but are you making opportunities available for the previously disadvantaged people also advance? Because we still have pay differential. We still have a majority of our people not being afforded opportunities to advance and to excel. But beside affirmative action, inherent requirement of a job, there may be justifiable, rational, grounds why it's happening. Hence, our saying is deemed to be unfair until it's proven. If the employer fails to prove that so by it, then the employer will have to take corrective measures to deal with that discrepancy or discrimination.
Let's talk about sexual harassment.
Yeah.
I think I'll ask him, three questions. Number one, what if workers fall in love and the employer has a policy that says this is not allowed?
We can't regulate relationships and feelings.
Yeah.
That's the thing. However, as an employer, if you say to employees to say, look, we cannot interfere with how you feel. However, one, we look at power relations. If you are in a position of authority, be very careful not to give in to your edges or your feelings, because you may be accused of abusing your powers, using the position given by the company to promote the business interest, but now you are promoting your own personal interest. And employees who are vulnerable, fearful, and desperate, they may be viewed to have, having agreed with you because they don't have a choice. They are afraid of losing their job or being treated otherwise. So as a person in authority, you need to be careful. Two, if people fall in love, because, people are people.
Yeah.
You cannot stop them. If one's Cupid strike to say, however, employers are saying, you need to disclose. You mustn't disclose, Ntando.
Okay.
Now, HR, I've multiplied, I've extended my relationship. And the other party must also disclose. If you fail to disclose, then you have broken the rules here at home and the employer can take action. That's an effort to deal with relationships within the workplace. And other people may say, look, even if I'm married, it's an extramarital affair. In terms of my culture, my wife knows about this. So there's no issue. Now be very careful not to interfere with my culture. If you put it like that, then the employer can go further and say, I need proof that
of the agreement.
Your wife knows about this. In your culture, do you know about this?
Yeah.
Yeah.
Absolutely.
You see. So, and normally, when you have workplace relations, be very aware that it may be a career ending. And you're opening yourself to issues of blackmail. And your career may come to an end. If it's proven on a balance of probabilities that indeed you have done what is alleged. You cannot prey on the vulnerable and the weak.
So this applies to the business owner.
Yeah, to everybody. Thirdly, even in the context of a consenting kind of a relationship where people have agreed, you may find here within that context that there's also that harassment. Because harassment is any unwelcome conduct of a sexual nature. It's either the victim will tell you that I don't want, or by their conduct, they'll just walk away, or they won't respond to your emails, your WhatsApp, your voice messages, and then they will raise issue of harassment. However, if it is raised, everybody is innocent until proven guilty. Even the alleged perpetrator needs to be treated fairly until a determination is arrived at to say you are guilty and you walk, And no employer would like to touch what you call sexual pest. If it has been alleged that you have harassed sexually a people or an employee, and by the way, it's not only male to female, sometimes
also
same
female.
gender.
Yeah.
But it's just that for females, they do report. Males are shy to report or what, even if they feel violated. But everybody can raise it. They can try. And as an employer, you need not trivialize issues of sexual harassment, because here, sexual harassment has a huge impact on the dignity of an individual. Okay? Secondly, it is about the victim, not about the perpetrator. Your views does not hold until such time that as an employer, you have dealt with them. So don't trivialize, take these issues very seriously. Because if you fail to address issues of sexual harassment, you may be held vicariously liable. You may be deemed to be the harasser yourself as an employer, especially if it happens in the line of duty.
Yeah. The line is very thin. The line is extremely thin. And that's what I think most people don't understand. Most employees don't understand how thin the line is, because a tap on the shoulder like this to somebody else, that is violation of my personal space.
Absolutely.
Why are you touching me? So I think it's such a valid point to raise, and also one point that we need to educate strongly on, to say, mind your space when you're in the employment environment.
So if this is a problem, hugs out of the question.
Absolutely.
Her dignity. And the courts of saying this is a heinous crime.
Yes.
They take it very serious to say sexual harassment, it's a heinous crime that is visited upon the dignity of the most vulnerable in their workspace. Remember, women has been at the receiving end for a long, long time.
Yeah.
So it cannot be that as men we impose ourselves, we take charge, we take control. And imagine if a woman is forcefully made to do certain things from 8 until 4 in the afternoon. And when that woman comes home, she's miserable. She's mentally, psychologically. That's why they need to be protected. And as an employer, small employer, if you dare also try that route, you may be liable and you may end up paying lots and lots of money. Remember, a dignity of a person is priceless. And in putting an amount, there's a restorative justice. I'm trying to restore the dignity of this individual. Can even be asked to pay 1 million rand, even if the person was paying 5,000 rand per month. That's how serious and how...
I love the shock in your face.
No more hugs. I think we need to put policies.
No. We're not saying a working environment should be cold. We are saying be very careful what you do. Know your boundaries. You cannot behave like a bull in a crowd where you cross the lines, you are out of control. It cannot be. And the employer also needs to know that when these things happens, even if they've not been repeated, but they can happen under your watch. If harassment happen, you have to be proactive, deal with it, nip it in the bud as an employer.
So I can have a defense to say I didn't know because she or he didn't report to me as an employer, if it was between two employees.
Now, how did it come to your attention?
There's now a case at the CCMA.
That's why, but the Act says it must, firstly, we need to exhaust internal processes. But now here's the thing. Here's a small employer. You are the manager, you are the owner, you are the HR, you are the advisor, you are everything. Do I have to come to you to report yourself to you? I'll go straight to the CCMA and say, look, Ntando owns the business. He makes all the decisions. So going to him after
it's a waste of time.
It's a waste of time. And the CCMA will look at it. But the rule is, let's deal with it internally.
Can I just add one thing which is quite shocking? And this is going to blow your mind. And it's going to blow your mind in the sense that these acts do not only have to happen in the employment. We've seen many cases that have been taken to CCMA because of acts that happened outside of work. Maybe during, when people go out for drinks after work, all of those things. I've seen so many cases that have been reported to the CCMA after obviously exhausting the processes internally, where a certain employee was found guilty of that misconduct, and which was maybe against the policies to say, you are not supposed to engage with this person like this. You are not supposed to be in their space doing this and blah, blah, blah. And
so this includes calls and texts.
This includes? Yes.
Phone calls and texts.
Yes. And people have found themselves at the CCMA trying to justify that, but it didn't happen while we're at work. It happened outside of work. And employers have obviously taken it upon themselves to address the matter. Because
So on that, and justifying yourself at the CCMA, how do you distinguish between someone who comes and says, I am probably guilty, but not guilty. I was trying, but she was playing hard to get. And naturally, I have to keep trying again and again and again. And it's how the game is like.
A workplace is an adult world. If you come for the first time, you're told.
No.
Or you're not, even if you're not told, you can see that this person is not interested. Go and try your luck some.
Yeah.
But if you persist and you continue to pursue and you come and argue that, no, I don't know what will inform your conduct. Some people say, no, in my culture, but in a workplace is a diverse environment.
Yeah.
There are many cultures, there's a heterogeneous environment. So you need to be very careful. And in my view, if you say that, it's an admission that indeed you did it. Now, going to the point, the hand of the employer is long enough to reach even outside the workplace. Because when you knock off at Hope Alive, you are an employee of Hope Alive. You are not dismissed. You have not resigned. You are still an employee. Now, if something can be established that what you did in Tembisa has an impact in the brand Hope Alive, then Hope Alive can take disciplinary action against you. Imagine if you rape in Tembisa and you come back here, it's reported you have raped a colleague, and then Hope Alive says, no, it was after hours. I'm sure many of the activists will come and do it here.
Absolutely.
So it doesn't even have to be a colleague. It can be something that you did outside of work with someone who does not work for the company.
Exactly. The brand and the reputation of the organization is always at stake. We need to be very, 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 very careful. And this is important because normally with small business, I don't know, small employers, I'm generalizing.
Yes.
It's important for them, much as they follow the legislation in terms of their taxes, company policies, your UIF, they must not exclude the labor laws out of the whole thing.
Yes.
It cannot be, because once you kick that out, you're opening yourself for a lot of challenges. Just look at that law, just follow it, observe it. Every workplace must have a human rights culture. Period.
Okay.
That's it. A human rights culture recognize that everybody has got the right to be heard. That's how simple it is.
Yeah.
I mean, if you are a corner shop owner, you employ 2-3 people, and we are not saying go and get a chairperson. Your decision should be informed by a sense of fairness. You have a right to employ, you have a right to terminate. The law does not have an issue with it, but act fairly.
Yeah.
Under all circumstances. If you are not sure, ask. Now, people want to isolate the law and choose which one they will comply with, which one they won't. You're opening yourself to all forms of attack. The CCMA is not a hostile organization. That is why the services are for free. You come in there, you get free service, free explanation, and you live there with your dignity intact. You see. Now, unfortunately, people like to listen to stories, horror stories at Chezanyamas after years, social gatherings, because you need to go to the source and find out exactly, CCMA, I have a challenge, I have this problem. What am I supposed to do? If you need to make a contract for an employee, written one, you don't know how. There's the Department of Labor. They've got pro forma contracts where a simple contract that outlines the basics, because the BCA is very clear about the written particulars of an employee. Who are you? Who am I? So that if there's an issue, the employee knows your details as an employer. If they have to refer an issue. The thing is, sometimes you always think about the West and we want to hide things from the employee, thinking that if they have issues, you'll not be found. And we cannot establish as to what are your details so that you can be served. Let's just be a passport, and let's just be transparent.
Yeah.
Yeah.
Mr. Melifa, please can you repeat that again? Because I feel like I don't want, especially the small businesses, to miss that. Where can these templates of contracts, where can one get them if they don't have one? Because I get a lot of people, because I'm from HR, a lot of people coming to me asking me if I have a template. Where can small business owners can acquire such?
The nearest Department of Labor.
Okay.
You can get them online.
Okay.
If everything fails, then you are there.
Okay.
Yeah.
Perfect. I hope everybody got that.
You see, the problem, people die in silence.
Yeah.
And at times, people want to claim knowledge and authority in things that they are not expert on.
Yeah.
You cannot speculate and do a guesswork.
Yes.
Yeah, I mean, all of us as individuals, we are blessed with different expertise, and we are qualified differently, and together we can be able to complement one another and assist one another in case there is any. The CCMA is there.
Yeah.
The Department of Employment is there. You can just go in free of charge and get first-hand information, and then from there, live happily ever after. You see?
Wonderful.
Yeah, wonderful. And with regards to payment, statutory entitlement in terms of your salary after you have worked for it, of course, your pay, your notice pay, or other entitlements. You have deduction on the side of the employer. Those are things that normally are contained in a contract.
Yeah.
But in terms of compliance, we need to comply. You cannot deduct a salary of an employee without an agreement. You cannot withhold a salary of an employee without an agreement. Because when you withhold that salary, how are they going to come to work?
Yes.
Because once I've worked, you owe me as Hope alive. I don't owe him. So give me what is due to me.
Yes.
And then we can happily live.
When you say you can't deduct without an agreement, verbal agreement is okay in that respect.
A written agreement is prepared so that you are safe and I'm safe. Remember, this written arrangement protects both of us.
Exactly.
To prove if there is some. But now we are always suspicious to say, but if I write it down, then he will know. No, don't do that. Just make life simple for yourself. Reduce these things into writing. If you deduct, and you must quantify. You cannot come with a shirt like this that you get at this shop for 50 rand. And suddenly, if I burn it or something happened to it, I stain it, then you say it's 500 rand. You will have to bring that proof. Where did you buy it?
And how much was it?
Yes.
Yes.
You see. So sometimes we try to be clever.
Yeah.
If I put it in brackets, where we want to rob people in a very decent way, undercover. I mean, if you say this thing costs so much, this vase, this cup costs, produce proof. And fortunately, with modern day with Google, we can be able to say, this thing, in fact, you got it for free. You didn't know it.
But also, let's speak about garnishes, because those don't necessarily need to happen with an employee and employer. Can you just take us through the validity of those garnishes? Because then now that obviously is a deduction to an employee's salary.
All right. Okay. Let's complete the first one.
Okay.
About the payment. If the employee, there has been non-payment, etc.
Yes.
You can refer matters to the CCM or the Department of Labor. At the CCMA, this will be your Section 73 capital of the BCA. Money is owed to me by the employer.
Yes.
Yeah. Then we'll deal with it. The employer will be invited and they'll come and explain themselves. A garnish or an emolument attachment order. This is a court order.
Yes.
It sits on your table. You cannot, as an employer, it's an order from the court. You must comply with the order. Garnish the employee's salary. You are hereby instructed to do that.
Yep.
So it's a court order. There's nothing that you can do about it except to follow the garnish order and do as ordered by the court. It's a court.
Yes. And a lot of people who have run away from their duties, parental duties, they've actually seen the hand of law reach their pockets, through the employer. So, and that's why I'm speaking about it, because, a lot of people then, by hearing this, to say the employer cannot deduct, they would say, but why is an employer getting in my personal business? But as you've just said, it is a court order that goes to the employer to say, so-and-so has not paid maintenance for a child, therefore we are going to, you employer, deduct a certain amount of money from his salary and pay it to whoever is obviously.
And if you want to challenge it, of course, go to the courts that issued
the court order. Yes.
Deal with the court. Leave the employer out of the whole thing.
Yes.
Deal with the courts.
Yes.
And if the court says, no, we know nothing about that garnish order, therefore it's a nullified, then they'll give you that in writing. You can go and show the employer to say, this is a fraudulent, this garnish order is fraudulent, and therefore I'm from the court with jurisdiction with authority. But you cannot. The employer has no choice.
Yeah.
Yeah. If the employer does not comply, then the employer will be in trouble.
Absolutely.
So,
I'm looking at a case like that, or any case that has gone to the CCMA, but the worker still has to go back and work for the same company.
Yeah.
Are there challenges that you've experienced with that get reported, that the work environment has gotten unbearable because I took the employer to the CCMA, no matter what the judgment was?
Of course, sometimes you get that situation that, now that I've been reinstated or I've been reemployed, I won the case, when I return back to work, the employer now is not pleased about that, they are doing other things, then we can still return to the CCMA, and then the CCMA, we call it occupational detriment. You are forced to suffer some occupational detriment because whatever you have done, you can return to the CCMA, and the CCMA by all means will do the right things, and you may even end up in the labor court. So it's very, very important.
So when there's a return case like that, the employee would still have to go back even after case number 2.
If the CCMA says go back, you have to comply. Go back. Unless if you told the CCMA that I don't think I can trust the employer anymore. Then the CCMA, you need not even explain yourself. The CCMA will have to look at whether compensation is the appropriate remedy under the circumstances. Same applies to employer. An employer says, no, these employees I cannot take back because the trust is broken. Trust is central to every relationship. Sometimes it's obvious from the misconduct itself, but at times the employer will need to, tell more than just saying the trust is broken, so that you assist the commissioner to make a fair determination, because we cannot force an employee to go back. We can't. And we cannot force an employer who gives reason that I cannot reinstate because of X, Y, Z. We'll apply our mind and come to a fair determination.
On that as well, I just want to take us to a case that I've seen play out, and there was just never any resolution. This was an internal case where I think it was a manager not acting in accordance with the laws of the company, if I may say, or just not behaving the way that they should as a manager. And this employee obviously reported this case to the respective departments, because obviously I think with them it wasn't HR that was handling that. I think it was employee relations that obviously looked at this case. And the case went up to sessions. I think there was about 4 of these sessions that happened, and there was never an outcome, even when the highest power was involved. In this case, would have been a CEO, and there was never a decision that they arrived to. Now, if that is the case, what is then the recourse of the employee in that situation where they've reported a grievance based on whatever conditions that they've obviously stipulated on that grievance, and that grievance almost just disappears because it's not dealt with the right way, where there is actually a decisive measure put in place to say, we move you from this line manager to, if obviously everything is substanted, but it's just left, to the employer to decide what they do. What then is the recourse of that employee? What should they do after this? They're not finding joy with the internal processes, because remember, they're still employed, so they have not been terminated, or the perpetrator hasn't also been terminated. What then is the recourse internally when you don't get joy from the processes?
Yeah, the saying, the strength of a crocodile is in the river. Yeah. So a workplace constitutes a river for the employer, where they've got powers and they can act anyhow.
Yes.
Now, when you don't get joy out of that process, that's when now you go to a neutral forum, where the strength of the employer may be neutralized. You refer such a matter, you can elect to choose the route of the LRA, where you refer an unfair labor practice, because the matter has not been addressed accordingly. You can choose the route of the EEA, where you're going to refer an issue of bullying or harassment.
Yes.
The EEA, then let the CCMA deal with the matter. Because it's common practice that some employers, they would like to
bury things under
they do.
And say, no, we've dealt with the matter. It doesn't mean if you declared a grievance and it was not dealt with, or the outcome is not to your satisfactory, you still are allowed to go to the CCMA. You're still employed, but you can go and declare a dispute with the CCMA. because we see these things happen. People in authority, that's why we say power is necessary, but power corrupts.
Yeah.
We all want power, but once you have tasted power, you become corrupt, you become abusive, you act, the way you want, you become invisible, untouchable.
Yes.
You think you are above the law. You're looking at this vulnerable, poor employee, you think you can walk over them. Then when you are taken out now to your equals or even people who are better than you, then you are in trouble. And remember, an employee, even if you don't recognize a union, even after the dismissal or ill treatment, they can join a union and you'll meet your equal at the level of the system.
And in this case, there was a union, but there was just never any resolution. Now, my point is to say there's no resolution, you're still under this particular offender of yours that you're reporting into. Nothing has been done. You've taken them through this process. Now, if you resign, would we call that constructive dismissal?
Alleged constructive dismissal until such time that it is proven that indeed the environment was so toxic and intolerable, it impacts on your health, because that's where you get mental illness.
Absolutely.
Psychological, because some workplace do not care. They are so horrible in how they treat employees. An employee end up having unintended consequences flowing from that. Yes, you'll come through the CCMA, and the CCMA will not prejudge a case. We'll hear the case, and then an appropriate decision will be made. Now, at times, what happened now, if maybe you go to the CCMA, there's a ruling in your favor, let's say the one that speaks in terms of money, and the employer refuses to pay the money or choose to pay less, come to the CCMA and the CCMA will be able to assist you. If it speaks of reinstatement, reemployment, and the employer, you come here, hope alive, management says you must not even put your foot, don't put your foot by force. Come back and go to court, and the court will be able to deal with that matter, and they will harass because they are more powerful than you.
Yeah.
What about performance management?
Of course, when you enter into a contract of employment, it places obligations and duties on both parties. As an employer, you are to receive this employee, make sure that the environment is healthy and it's safe, pay them and respect their human rights. As an employee, you agree to avail yourself, to present yourself at work, to perform in line with the standard at work, to respect the employer, to not to sabotage the employer, and to promote that, act in good faith all the material times. Now, if there's a performance standard in the workplace and you don't reach that standard, obviously the employer will have to sit around the table with you and say, look, these are the standards in terms of your KPAs or KPIs. We are not happy. You are not reaching the standard. Let's have a talk. What is the issue here? Now you may be able to say, but you are giving me old, outdated tools here. You are giving me a truck or vehicle that gets stuck every day. All those things. And then let the employer come in with remedial action to assist you, to support you, to train you, to counsel you, to give you reasonable time to meet the standard. And when all that has been exhausted, then the employer reserves the right to say, look, or you can even give you an alternative job, but if it's not there, we think we'll let you go because you are a complete failure. We've tried. So the employer have that right all the time. Employees also have the right not to be treated unfairly. So you can prove to the CCMA that, look, I did the following. I've given you a chance. I've given them support. I've given them counseling. I've given them training. I've extended this decision over time. I have no choice but now to come to this conclusion. Unfortunately, we are going to
So if those things haven't happened, the employer doesn't have a case.
If those things haven't happened, you just wake up and say, look, I've been watching you. You are not doing the right things. You are not cutting it. I think Friday,
It's your last day.
you're out of here on Friday. And then you come to the CCMA ask you, okay, before you even arrived at the dismissal, there's a vacuum here. There's an empty space here. Fill it up for us. What did you do or do?
Yes.
Is it fair or not fair?
Mm.
Then we'll make it. But we'll start with conciliation first.
Okay.
And just to add on to that, Dando, which is the most funniest thing, and I think a lot of people don't understand this, that during your probation period, just because the contract has a probation period that says you're only here for 3 months or 6 months before we can actually consider this contract permanent. Even during that time, the onus is on the employer to make sure that they have given you all the support that they can, the training, the counseling, as it said. So just because it's a date to say, we give you 3 months to assess whether this relationship can work or not, does not mean then the employer sits back and watches you fail. They have still an obligation to make sure that you meet the standards, performance standards of the organization. So that would mean that making sure that the training is offered, the counseling is offered, the clarity on the KPIs is quite clear. And I think we've spoken about this quite a number of times to say that performance contract has to be in place. It doesn't have to be, the sophisticated ones that we see from big corporates, but a simple page to say, I expect you to do these things during this time, and this is the success. This is what success looks like, So once that is clear and the employee understands what the expectations of the employers are, to my employment, then if that individual, that employee still is not able to meet those requirements, then you can, the employer can dismiss you. And there's no grounds for you as an employee now to say you are not able to, because firstly, you apply for a job and you said you had the skill. Now you have given the opportunity to do that and you're still unable to, and you've been trained and counseled and everything, and you're still failing to do that. So there is no grounds for you to then obviously lodge a case, a dispute.
Still on what you're saying.
Yeah, look, your probation, like you correctly put it, it's for newly hired employees. You want to test to see whether they fit into the culture of the organization. But like the colleague has just said, you need to demonstrate that you have done all these things.
Yeah.
And also the standard must be doable and the time must be reasonable.
Yeah.
So all those things the employee can say, but they didn't give me reasonable time. In terms of what are the requirement, it was unreasonable for me to achieve this within 3 days. We needed extra 2 days.
Or what if the employee lied on the CV and 3 months?
Let's come to that.
Yeah.
If you are a senior manager, you have been employed on the basis that you have the expertise, the qualification, the experience, the knowledge. You cannot find shelter under probation like it happens to ordinary employees, because you're expected to hit the ground running. You've sold yourself very high at an interview, or you have even been headhunted to say you can turn things around, you can make sure this Hope Alive Radio grows, etc., etc. But you are failing. And you'll be held to those weights, and you'll be held to what you said, because you are a manager. Remember, manager is as good as an employer. You are senior, you are an executive. Now, in the absence of any other person, where must the employer look at? So hiding under probation may not assist you, unless if the agreement was very clear that in a contract, yes, you are on probation. That's something else. So senior manager, fit very carefully, because you are high rollers and high earning people.
Absolutely.
Must be equal.
And just in general, overselling yourself on a CV on things you can't do.
Yeah.
Yeah, it may be you have, punched above your weight and now you are not able to rise to the occasion. And the employer may by all means say, look, you misled us in that process. And therefore now we believe we have to get somebody better. So that process will not be followed of probation.
Thank you. I think a final one for me, I know my friends would absolutely shout if I don't ask this. What rights or what options do employers, business owners have if the business is going down and they feel they want to retrench and they haven't been obviously they were not planning to let anyone go, but now they've suddenly find themselves in a situation where business is saying, 2-3 people need to be let go?
Yeah, that's a good question, because at the CCMA, we have a unit called the Employment Security Unit. So once an employer sees that they've got challenges, whether it's technological, structural, economic, or any similar needs of an employer, mainly when people are suffering financially, they are not doing very well. At that point, you can, because at the CCMA, we have this training layoff scheme where you can contact the CCMA with the employees. At CCMA, we want the presentation on a training layoff scheme. We want to understand, because we are facing operational challenges here. We want to understand how can you step in and assist us. Now, there's a moment that people and a commissioner will make presentation online or can be dispatched to the workplace to come and explain the training layoff schemes, how does it work, and what is the aim of that scheme to assist employers who may be facing
business challenges.
Yeah, business challenges or operational challenges. And that will be rolled out to say, look, this scheme is called a training layoff scheme, wherein the contract of employment of employees is suspended. And whilst they're not dismissed, it's suspended. Whilst it is suspended, these identified employees can get into the training with the relevant SETA to able to upskill or reskill them, so that when the business finally recovers, they'll be ready to go back. But it happens within a period of 12 months. Now, you will have to make a business case to the committee that sits and adjudicate over whether you can be rescued or you cannot be rescued. Now, for the period of that training, the employees will be getting not a salary, it's an allowance. 75% of their wages they will be getting from the scheme itself.
Imagine.
Oh, not from the business.
No, from the scheme itself. And most employers spend a lot of money on their wage bill. And imagine if your wage bill is reduced with 65% or so. It's a lot of savings. The money can be directed somewhere in the interim while the workers are getting a skill. And those things can be done once people cry out, their cry is heard, and then these type of intervention may come in handy for them. You see, because it's no use sometimes if we complain to the wrong forums, but we don't go to the right forums.
My mind is blown on this, because a lot of us don't know that there's actually such a scheme that is there.
Apply, and then it will be determined by the adjudication committee whether really if we assist you, and it's a win-win situation. Even if employees come out with a skill 12 months down the line, they come up with a skill, the company has not recovered, at least they have evidence that they are qualified in this or that.
Yes.
They can open a corporation, or they can go solo, or they can go and, put that on record on their CVs. So these are some of the things that are available from the CCMA. As I'm saying, the CCMA is so user-friendly.
What's the criteria?
What evidence am I bringing?
Look, if you say you are facing a crisis, it's possible that you may end up having to reduce staff to maximize or to save money. That is the opening point where you can now say, CCMA, bring the presentation, and it's a voluntary process, of course. If you agree with your workers or the union, there will be documents to be completed, and hence I'm saying your business case also will assist the experts who sit on that panel to determine whether, these people need help. But remember, the intention is to help, not to deny help.
Oh, that's wonderful. And how many times can one seek for this help?
Yeah, no. Look, come and look for help. Well, how many times we'll cross that bridge?
Yeah, because you know why I'm asking this is
Yeah.
because, I mean, obviously we all know the markets. They are absolutely
They keep changing.
They keep changing. Every single day is something new. I mean,
Yeah.
right now you could resuscitate your business, but then in the next five months, you know, after the elections, it takes a different turn again after you've just been assisted. So
you want to check if the CCMA won't call you a problem child every
No,
5 months. You're back.
yeah,
Well, what you say is very true, because sometimes you may not be stood up with the business principles. That's where now the CCMA, in conjunction with other organizations, Department of Economic Development, Department of Trade and Industry, Productivity South Africa, Department of Employment and Labor, they can even dispatch some people to a company to say, look, you're running a company like a spaza shop, but I'm generalizing.
yeah,
You put money in your pocket, you don't have strategies, you don't have, budget, you buy as and when you want to buy. So your strategy, your business model is outdated. It cannot work. Let's keep you in line with people who are competing with you, so that you can market your products, you can come up with good business skills. Let's give you a model. And then from there, the business can thrive.
wow,
Because some people, you never plan for a business, you get the full package. Then because you see millions, you say, hey, I'm now going to get into this business. But you don't know the weaknesses and the strength
yeah,
and the strategies, or in that you didn't do any analysis. You happen to be blessed with the monies, but you are lucky in other things. So these are things that may come to you for free via the street GLS scheme.
Just one more question. I need to ask this one because if there is such remediation, why are we not seeing corporates taking advantage of this? Why are we seeing a lot of corporates retrenching people based on operational reasoning?
Remember, the law does provides that you can go the route of operational requirement and follow a fair process, or you can be challenged.
Yes.
Yeah, the law does provide. But
Yes.
if you are aware of this alternative, you take an opportunity, you may succeed or you may not succeed. But there's a take on this scheme, but not to the way we expected, but we're beginning to see the light. Hence, with platforms like these provided by Hope Alive,
Nice.
we are able to break down and tell to people that, no, here's help.
You have options.
You have options. Don't cry alone. Because one knows
Absolutely.
go out there, seek information, and speak to the right people.
Absolutely.
You cannot come together in a room as people who are fellow strugglers and just cry and cry and cry. Look outside the window and see if you can get an assistance from somewhere. And it's very easy, very easy. Government is responsible for job creation and job support. That's why we have this employment security unit at the CCMA.
Thank you.
Now, you will love the CCMA.
I think I'm going to love it.
Yeah, when he comes to workshops, sometimes he says, I come in peace.
Yeah.
By the end of the workshop.
Now I see the peace part.
I'm also doing.
You will
There's
all
so
know
much.
that CCMA can be your friend.
Absolutely.
And entrepreneurs as well.
Yeah.
Thank you so much for joining us and for sharing your wisdom.
Oh, thanks so much.
It was
Appreciate
amazing.
it. And like we said, our services are for free. Make a call, send an email, walk in there, cry, you'll be heard. And if we have jurisdiction in terms of what the law provides, we will assist you. If we don't have, we won't chase you away. We'll direct you to the right forum to go and seek assistance.
And this applies to entrepreneurs as well as it does to employees.
Fellow South Africans.
Mm.
It does. Everybody or everyone has got the right. So you had to be listened to. And I like the name of the station.
Shaping Minds.
Nice.
It echoes what the Constitution is all about.
Yes.
You must give people hope. Yeah.
Yes.
Thank you. And thank you for joining us. This is definitely one you will want to share with your friends, to share with, even if they're employed by small business owners and other small business owners from our side.
It's signing out.
We are signing out. Thank you.
Thank you.
Adios. Thank you.